Petitioner Cariol Horne was terminated from her employment as a City of Buffalo police officer after she intervened in 2006 to stop another officer from applying excessive use of force in effectuating an arrest. The subject litigation was commenced in October of 2020, seeking to vacate Supreme Court's prior ruling from 2010 sustaining the termination. The petition seeks reinstatement nunc pro tunc, which means now for then, as in they're going to make the decision now, but it's going to apply back then. The petition seeks reinstatement nunc pro tunc for a 2-year period, which would allow her to achieve sufficient credit to qualify for a full pension based on 20 years of service. Recent events in the national news, including the death last year in the city of Minneapolis of George Floyd, who died from unreasonable physical force being applied to him for over 9 minutes, have sparked national outrage over the use of this practice. In the case of Mr. Floyd, the police officer's actions were recorded by a concerned bystander using her cell phone. That video was subsequently seen around the world, sparking national demonstrations against such excessive use of force in police interactions generally. One of the issues in all of these cases is the role of the other officers at the scene, and particularly their complicity in failing to intervene to save the life of a person to whom such unreasonable physical force is being applied. The Floyd case, as well as other notable cases in New York State concerning Eric Garner, for example, both involved multiple officers who either did nothing or actually assisted the officer in applying the physical force, even while individual bystanders were crying out that he could not breathe. In the wake of a renewed national and local awareness of the problem of excessive force, and with police officers who intervene now being seen as heroes, much local support was generated to rectify the penalty that was imposed on Officer Horne, who had been terminated from her employment and whose termination was upheld in the original Article 78 proceeding brought in the Supreme Court in 2010. To her credit, Officer Horne did not merely stand by, but instead sought to intervene despite the penalty she ultimately paid for doing so. There doesn't seem to be a lot of information about the incident that happened in 2006. We didn't have ubiquitous police body cameras back then, so there's no video of Neal Mack's arrest, at least not that I was able to find. So the information that I have is that former Buffalo police officer Cariol Horne was fired in 2008 after she says she stopped a white officer's chokehold on a black suspect who was already in handcuffs. This is according to a CBS News report. Horne was fired just before reaching her 20-year veteran status with the Buffalo Police Department, which would have qualified her for a pension. But in 2006, then Officer Horne made headlines after intervening when she says fellow officer Greg Kwiatkowski was choking a black suspect whose name was Neal Mack. Neal Mack looked like he was about to die, Horne said. So had I not stepped in, he possibly could have. He was handcuffed and being choked. The Buffalo Police Department brought disciplinary charges against Horne and fired her in 2008, a few months before she was eligible to receive her full pension. Kwiatkowski sued Horne and her lawyer for defamation, and in 2011, the judge found that 8 of the lawyer's statements, Horne's lawyer, those statements were defamatory and false, including the claim that Horne saved the life of a suspect who was already in handcuffs. I guess it wasn't certain whether she actually saved his life or whether his life was in danger, but he was apparently being choked by Greg Kwiatkowski, according to all this information. Mack, the suspect at the center of a nearly 14-year-old case, maintains to this day that Horne saved his life. Quote, "He was choking me. I was handcuffed," Cariol Horne said. "You killing him, Greg." And she reached over and tried to grab his hand around my neck, said Mack. In 2012, in a lawsuit brought by Mack, a jury found no wrongdoing by the Buffalo police officers involved in his arrest. As for Kwiatkowski, he was later sentenced to 4 months in federal prison in 2018 for using unlawful and unreasonable force against 4 black teenagers in a completely separate incident. Unlawful, unnecessary force, says Horne, the same thing that I said he did. As a result of the local support generated for Officer Horne, on September 29, 2020, the Buffalo Common Council adopted a law known as Cariol's Law, the duty to intervene. The new legislation creates a duty to intervene when an officer observes force that he or she reasonably believes to be clearly beyond that which is objectively reasonable. The bill also creates a cause of action with a 20-year statute of limitations for officers who have been terminated for reporting or for intervening to stop the use of excessive force. So, interesting law. The officer must observe force that he or she reasonably believes, so you've got a reasonable person standard on the belief, to be clearly beyond that which is objectively reasonable. So it's an objectively reasonable standard for the force, and then the standard for the belief of the officer observing the thing to be beyond that which is objectively reasonable is a reasonability standard themselves. So there's probably some wiggle room in there, but I mean, hey, how are you going to create exacting language on this? This is pretty close to what I would expect for language to hold an officer to some kind of standard. And the courts will then further define what this reasonable person standard is for these beliefs and the force and the observation of it as they see new cases. So this does seem to have some kind of teeth to it to put officers on notice that they have to intervene if they see a problem occurring. 2 days after the Common Council adopted the new law, but before it had been signed into law, the subject litigation was commenced by the filing of a petition and then a notice of motion on October 2nd, 2020, seeking to vacate the original order and judgment of this court. The original petition had been brought in 2010 pursuant to CPLR Article 78, seeking to vacate the hearing officer's findings and recommendation. The original notice of motion sought the following relief: an order annulling the findings and recommendation of hearing officer Thomas Ronaldo Esquire and directing respondents to fully restore petitioner Cariol J. Horne to her position with full payment of any loss of wages and benefits effective May 8, 2008 through the date of this court's 2010 decision pursuant to New York common law. The motion in support of this petition was predicated on the court's inherent authority to set aside its own determinations. On October 28, 2020, the mayor signed the bill into law amending the charter of the city of Buffalo. The petitioner then filed an amended notice of motion seeking to add a second cause of action predicated on the now adopted charter amendment known as Cariol's Law. In sum, as sought in the petition and by way of the motion, the petitioner seeks to 1. Vacate the prior order and judgment of this court. 2. Annul the findings and recommendations of hearing officer Thomas Ronaldo. 3. Vacate the termination of petitioner's employment as a Buffalo police officer by the respondent city of Buffalo. And 4. Be reinstated to her former position and rank with back pay and benefits for the period of termination from May 8, 2008 through August 4th, 2010. The respondent filed an affirmation in response to the motion, noting various facts surrounding the subject incident and summarizing the extensive 12-day hearing which had been conducted. The respondent attached exhibits, including the hearing officer's extensive 47-page findings and recommendations and a May 4, 2008 memorandum from the DA's office concluding that there was no basis to find perjury or criminal conduct by the officers who testified. The opposing papers closed by stating, in deciding the instant motion, the city respectfully asks the court to reach a fair, just, and proper result in light of the facts and circumstances involved, including the record presented to the court for review. The facts were sufficiently stated in respondent's affidavit. On November 1st, 2006, Officer Horne responded to a call of an officer in need of assistance. Upon her arrival, petitioner witnessed a fellow officer, Gregory Kwiatkowski, engaging in a physical struggle with a suspect, Neal Mack, as Kwiatkowski attempted to escort Mack to a patrol vehicle incident to Mack's arrest. Petitioner intervened in the arrest by coming into contact with Kwiatkowski. Petitioner claims that it was necessary for her to intervene to stop Kwiatkowski from using a chokehold on Mack, who was handcuffed in the front. As noted above, Officer Horne had disciplinary charges and amended charges filed against her on January 25, 2007 and May 30, 2007. The matter came on for a hearing in accordance with the provisions of Article 12 of the collective bargaining agreement with the city. Hearings were held, etc. At the conclusion of the hearing officer recommended termination, which was then adopted and sustained in an Article 78 proceeding brought in the Supreme Court, this same court, Supreme Court of Erie County, which again is the lowest court. It's a county court in New York. It should be noted that the hearing officer, while recommending the termination of Officer Horne, found that such a penalty was only supported by the actions in the 6 charges related to the physical altercation with Officer Kwiatkowski. Relevant to this inquiry and unknown to the hearing officer and to the court in 2010, Officer Kwiatkowski has also been involved in the arrest of 4 African-American teenagers in 2009, where his conduct was alleged to have been excessively violent, including slamming the heads of those arrested into a car. 5 years later, long after this case had been heard and decided, Officer Kwiatkowski pled guilty in federal district court for the deprivation of their civil rights, for which he was sentenced to 4 months in jail and terminated as a City of Buffalo police officer. As stated by Justice Brandeis in his oft-quoted dissent in reviewing the government's use of its police power, if the government becomes a lawbreaker, it breeds contempt for law. It invites every man to become a law unto himself. It invites anarchy. The petitioner's original application sought to vacate this court's decision and the subsequent order and judgment. The unique factual situation presented here does not fit well into any of the statutory grounds under the CPLR 5015 upon which this court could base a decision to vacate. However, a court also possesses the inherent authority and discretion to vacate its own judgment beyond that granted by statute when appropriate. A specific statutory restriction may operate as a prohibition on the court's exercise of such discretion. There is, however, no such specific statutory provision applicable here. In fact, it would appear that the specific provision of the city's recently enacted ordinance provision, the Retroactive Protection for Officers section, actually provides the authority for the court to exercise such discretion in this particular case. So, Carriel's law really was Carriel's law, as it provides for her reinstatement as an officer in the City of Buffalo Police Department. And then she apparently is accepting termination as of August of 2020, and that will give her the amount of time to get her full pension. The original determinations in this case by both the hearing officer and this court lacked significant information about the conduct of Officer Kwiatkowski and his misuse of physical force in effecting arrests. Likewise, the current societal view towards the use of chokeholds and physical force in effecting arrests, along with the City of Buffalo's expression of specific disapproval of such force by legislative enactment, in other words, they made a law, has altered the landscape. The court will therefore grant petitioner's request to vacate the original determination made by the hearing officer upon which the city based its decision to terminate Officer Horne. Likewise, the city's termination of Officer Horne's position as a member of the City of Buffalo Police Department must be vacated as well, reinstating her as an officer for the period of July 26, 2008 through August 4, 2010. Request for relief under the newly enacted charter amendment. Although the petition and motion were originally predicated on the court's inherent relief to vacate its own decisions, the amended affidavit and the supplemental submission asked the court to also rely upon the new cause of action created by the City of Buffalo's 2020 legislation. That legislation says, any police officer found to have been terminated for reporting the objectively unreasonable use of force against a civilian or intervening to stop the use of objectively unreasonable force by a fellow officer within the 20-year period preceding the adoption of this law may have said finding reviewed by a court with competent jurisdiction. The respondent, City of Buffalo, has thus already created a cause of action to specifically address petitioner's situation. Furthermore, the respondent, City of Buffalo, through its legislative and executive branches, has already determined that Officer Horne intervened appropriately. The legislation passed by the City Council and signed into law by the mayor states as follows. Whereas, in 2006, police officer Cariol Horne intervened to save a civilian from being harmed by a fellow police officer and had her employment terminated. Now, therefore, be it resolved that the City of Buffalo codifies the duty to intervene, Cariol's law. The City of Buffalo, through its legislative and executive branches, has thus already determined that Officer Horne intervened to save the life of a civilian. Further, the city, having already acknowledged that Officer Horne is entitled to a finding that she acted properly, has not opposed the relief requested in the motion. Enforcement of this cause of action that the city created by legislative enactment is more appropriately the subject of a plenary action and not as an additional request for relief attached to an Article 78 special proceeding. However, under CPLR 103C, whatever that is, the court has the authority to consider the relief being requested and to treat such pleadings as compliant. For the proper prosecution of this civil case, the court will deem this a hybrid special proceeding and the plenary action to expedite a just and fair resolution. The same relief granted to petitioner under the Article 78 petition is likewise granted to petitioner under the provisions of the Charter Amendment. Because the city has enacted the ordinance and has acknowledged the claim of Officer Horne, the court may make a summary determination on the undisputed facts and law. Quoting the words of Dr. Martin Luther King Jr., the time is always right to do right. The City of Buffalo has recognized the error and has acknowledged the need to undo an injustice from the past. The legal system can, at the very least, be the mechanism to help justice prevail, even if belatedly. While the Eric Gardners and George Floyds of the world never had a chance for a do-over, at least here the correction can be done. It is therefore the decision of this court as follows. 1. Petitioner's original motion to vacate the decision of this court is granted. The findings and recommendations of the hearing officer are hereby annulled. The termination of the petitioner as a City of Buffalo police officer based upon such findings and recommendations is hereby vacated. The petitioner's amended motion for a cause of action under the newly enacted city charter provisions is granted. The court finds the petitioner would have been physically capable of performing her duties during the time period for which she is seeking relief, and the petitioner is therefore reinstated as a police officer with the City of Buffalo, now for then, nunc pro tunc, for the period of July 26, 2008 through August 4, 2010, I think they mean 2020, and shall be entitled to back wages and benefits for such period. The respondent, City of Buffalo, is directed to make an award of back pay in the proper amount and to make any required pension contributions for that period and to take such other steps as are necessary to implement this decision. It is so ordered and adjudged April 13th, 2021, the Honorable Dennis E. Ward of the Supreme Court of New York, Erie County. So that's a very remarkable situation. The legislature came together to remedy the injustice of the previous decision from 2010. Yes, she'll get a decade plus of back pay and then have a full pension. So it will be as if she had worked that whole time and gotten whatever the normal pay would be for that period. I don't know how they're going to calculate that. A lot of times pension is based on your average pay over the last number of years. So very good situation in the basic sense that she was improperly fired for intervening to protect and serve a citizen who was not to be assaulted by an officer, and she got fired for it. So this is the right outcome, in my opinion. And I look forward to more accountability for police officers. Officers of the law, officers of the court, officers of the military are held to a higher standard. Except officers of the law don't seem to be held to that higher standard when it actually comes down to brass tacks. So I think that needs to change. Obviously, it's a hot topic right now. To just state my personal opinion and professional opinion, I guess, as well, officers should be properly supported by their cities so that they can do the right thing confidently. And they should also face accountability when they use those tools improperly and use their position of authority improperly. The point of a police officer is not to remind citizens that the state can squash them at any time. The point of a police officer is to enforce the laws in an even-handed way and help keep the peace. And that there really isn't a lot more to it than that. But in the United States in particular, there seems to be some problem with the view of officers' roles in society. What role should an officer play in society? So let me know what you think of Cariol's law and the court's decision reinstating her back pay, and therefore her pension will also get paid. I think that was the right decision, but I'd love to hear your thoughts in the comments below. So that's our show. Thanks for joining me. I'm Leonard French, your favorite copyright attorney, and this is Lawful Masses, your favorite legal news and education program, here on YouTube, also on Floatplane, and on twitch.tv at Sunday mornings at 10 a.m. Eastern Time. This is a community-supported legal education channel, meaning we need your financial support on a monthly basis on patreon.com/ljfrench, on sponsors.com/law, or through YouTube membership or Floatplane membership. Thank you very much in April of 2021 to our $50 plus supporters, Joe Tyson, John Steele, Gavin Barnard, Eevi, Spirit Bear, Benjamin Hitov, Ugly Grill, Rudolph Bescherer Jr., Torpedan, Brandyn, Abel, Sovereign Tittizen, ShadowTycho, RDHDragon, and Earthbound Star. And thank you very much to the $5 plus supporters. Everyone's been scrolling on the updated LED panel behind me and will be on the videos in front of me that drop. I love you all. Have a great week. I hope you all had a nice holiday weekend, and I will see you in the videos. Bye.
Your mum sounded better when she done the gobble gobble.